241, and we had a really lively discussion, and we decided that before we send it down to the third reading file, that any other questions that you may have, that you're given the opportunity to meet with the author of the bill, Senator Repeal. I understand now that there are going to be some amendments as a result of some of those discussions. So I recognize then Senator Repeal, and this is at really the closing point now of where we are in our discussion.
Thank you very much, Madam Speaker. And again, I want to thank Senator Espadon for all the questions and concerns that he raised relative to Bill 241-33. And this is again an act to provide for to establish a recycling industry economic stimulus program, and to provide a continuing appropriation for this purpose from the recycling revolving fund revenues. And yesterday afternoon there was a series of questions, and as a result of that discussion, we had an opportunity to go back to the Environmental Protection Agency, raise those issues with them, and over the night we've come up with 7 different amendments. Some are just technical amendments, but copies have been made and they are with each senator right now. So, Madam Speaker, the first amendment is to amend line 1 through 5 of page 3 and as follows. A recycling company has to be licensed to do business in Guam and hold a permit with the Guam Environmental Protection Agency for the processing, temporary storage, and beneficial reuse of recyclable materials. Recycling companies who qualify under this program shall receive $30 of each ton of solid waste recycled by the respective company. And the underlined words that I'd like to add to the bill continue to read, as documented with a bill of lading or similar documentation. Recyclable materials or solid waste imported from Guam shall not qualify under this program. And so this amendment recognizes Senator Espadon's concern that how do we justify or verify whether or not they're actually recycling these recyclables off island. And the other thing that we added is to make sure that we're not creating an economic stimulus program for recyclables to be imported into Guam only to receive this $30 per ton subsidy. So this is my first amendment.
On the amendment, Senator Blanche, you're recognized.
Thank you, Madam Speaker. I guess my question is to the statement, recyclable materials, solid waste imported into Guam shall not qualify under this program. For the most part, there could be an argument made that all the material that's going to eventually be exported was imported. So I think we need to clarify, we need to strengthen that language there so that we don't, by that, just nullify everything that's that could be classified as recyclable material per this legislation. I just don't want this to be perceived as saying, because if you read that, it says the material or waste imported into Guam shall not be.
We're going to take a brief recess.
Yes, please.
Yeah.
Back in session. Senator Blanche, you still have the floor.
Thank you, Madam Speaker. I think, and thank you for that recess. For purposes of just, strengthening the language, is remove recyclable material or, and start that sentence with solid waste.
So on the amendment to remove, delete recyclable material or, and that sentence should start with solid waste. No objections? So ordered. Thank you, Senator.
Thank you, Madam Speaker, and thank you for that amendment as well. Madam Speaker, the next amendment proposes to amend line 15 and 16 of page 3. It's relative to the FTE employee to make sure that this employee's only responsibility is to administer and implement this article, and so there's no cost sharing or supplanting. And so this amendment also has been provided to each senator.
I'm really sorry to interrupt, but you're right, and we were excited to kind of get through all these. But you're right, his amendment did pass for recyclable to delete, and then now for the entire amendment, you're right, for
Oh, I'm
it to
sorry.
then pass as amended. So on that, then, the amendment, there has been no objection, so ordered. Thank
That's
you,
correct,
senators. So I'm sorry, you may
Okay.
continue, Senator
Yeah,
Respicio.
so on page 3, line 15 and 16, Madam Speaker, just to add additional language so that it's we're certain that the FTE is only going to be there to administer and to implement this article.
Okay, on the amendment, the second amendment, no objections? So ordered.
The other amendment is to amend lines 1 and 2 of page 4, basically to add language relative to the private company. So the new language will read $100,000 to contract the professional services of an experienced private company to promote recycling in the community. And there should be an amendment to this amendment to ask the legal counsel to provide language to tie this into the RFP and the procurement process. And that was a concern raised by the good senator from Tamuning.
Legal counsel. We're looking at 241, the amendment about a $100,000 contract for professional services.
Maybe we can say such procurement shall be subjected to the Guam procurement law, and then you give the citation.
Or just and is subject to
Yeah.
procurement law. Okay, legal counsel, are we okay? All right, and that will be then, so the very first one is $100,000 contract. No objections, so ordered.
And so that amendment we just adopted, there would be additional language that would read, as you said, and is subject to Guam procurement law.
Yes, and is subject to the procurement law. Right, and which legal
Okay.
counsel would make sure that the
Thank
language
you,
is
Madam Speaker. The next
proper.
amendment is to amend lines 3 and 4 of page 4. Again, to add the words "the professional and technical services of an experienced private company to further develop and implement the priorities delineated in the Guam Zero Waste Plan 2013 and shall be subject to the Guam procurement law."
Yes, on that amendment. Senator Ada, you have the floor? You have a question?
Yeah, we're asking. Yeah, thank you, Madam Speaker. Yeah, it's so we're putting in the amendment to appropriate a certain amount to contract the professional services of an experienced private company to promote recycling in the community. Experienced in what? I mean, you could have somebody like G4S, who you see right now is getting contracts for landscaping. Before they started out with just security. And if, based on that, if we wanted to hire a company that was experienced in landscaping, then that knocks out G4S. But it doesn't really matter if they can bring the resources together and show that they can do the work. So it doesn't matter whether the company is experienced or not.
Senator Respicio, do you yield to the question?
That's a legitimate point. Certainly, and I guess when they do the RFP and companies respond to the RFP, they would have to demonstrate their ability to take the zero waste plan that was adopted in 2013 and try to make a go at it by way of being implemented. So I have no objections to deleting the words "and experienced." So it would just read "and technical services of a private company."
On the amendment, To the amendment, no objections, so ordered.
And I thank our resident procurement expert for his guidance to make sure that we're not skewing this so that it's tipped towards one company or the other. So I appreciate that guidance. So on
And
the,
of course, so do remember that he has added on and shall be subject to the procurement law at the end of that sentence. So, and no objection to that add-on, okay, so ordered. And then lastly now, the entire amendment that has been amended, no objections, so ordered. Thank you, Senators.
thank you. On page 3, Madam Speaker and colleagues, on line 13, just to delete the extra word recycling.
Okay, so on page 3, let me see, line 13, remove the extra word recycling, no objections, so ordered.
And the next one on page 4, line 7, to delete the word authority and insert agency.
Okay, page 4, line 7, delete the word authority, add agency, no objections, so ordered.
Thank you. And on page 4, line 13, to also change the word authority, to delete the word authority and insert agency.
Okay, so delete authority, add agency, no objections, so ordered. Thank you, Senator.
And then just to have the legal counsel, on page 4, just remove the hyphen, 0 hyphen. It just stands for end of communication.
And where, what number? Oh, okay, yes. And so we have legal counsel in the very beginning
Yeah,
to do
yeah,
all
she'll-
technical
yeah.
type of corrections.
Yeah, and Madam Speaker, I'm honored at this time to request that both Senator Barnes and Senator Espadon become the co-sponsor of this bill.
Okay, on that motion then, Barnes
Thanks,
and
Jimmy.
Espadon, no objections, so
And I
ordered.
thank everybody for their patience in how this bill evolved to being better. And Senator Tom Adda would be automatic.
And Senator, he's always in the very top. Okay, so ordered. So on the motion then to send 241 to the third reading file without any objections, so ordered. Thank you, Senators. Senator Fisher, you're recognized for a motion.
Thank you very much, Madam Speaker and colleagues. Notwithstanding the House rules, I move that we revert back to motions.
Hearing no objections, so ordered. Mr. Vice Speaker, you're recognized.
Thank you very much. Thank you very much, Madam Speaker. Notwithstanding the objection of the Audit on Bill 222, I move that we move for the override of Bill 222, and I'd ask for an opportunity to be heard.
You may proceed to the voting file, yeah.
So the voting file and have, it stays in motions, I'm sorry. Just to,
You were in motions? Oh,
yeah.
Yes.
But
so-
it does stay in motion. And
You're
then
right.
after the discussion, I move it down.
You're right, then the
into the
motion to
voting
go
file.
to the voting file.
Yeah. So, Bill 222, Madam Speaker, I seem to be perpetually tired. When I pushed for this bill the first time around, I stated I was tired having fought this for as long as I had over the last several months. And I know that many of my colleagues were a little credulous as to whether or not my concerns were well-founded when I introduced Bill 22. And at the time that I introduced Bill 222, was I wanted to make sure that it was clear that any governor, not only this one, but any forthcoming governor, and his legal counsel and his staff would understand that making retroactive pay was illegal and also bonus pays. And so that was the reason why in Bill 222, I made it very clear in Section 3 that there's a prohibition against bonus for unclassified and for retroactive pay for it. Many didn't believe that I thought that the way that Adelup was going to address the retroactive pay that they gave out in December 2014 was to give everybody a bonus in 2014. Much to my surprise, they issued another retroactive pay set. And I know many of you don't believe that that's what happened, but that is what happened, and it is what their office admits, or at least their press secretary admits. Because if we take the news story from last week, and I know we don't take it as gospel truth or Bible truth when we read the newspaper, but I think the statements made by Adelup are illustrative and education, or at least prove the point. And on February the 6th, the newspaper wrote, the governor's office spokesman, Oya, I won't attempt the last name, said Friday that even before the Attorney General had released her opinion, Barrett Anderson had engaged in ongoing discussions with Adelup about the retroactive pay raises and that steps had been taken to address raises based on this discussion. About 107 governors and lieutenant governor staffers received retroactive pay that were illegal because they weren't authorized by specific law. On the 9th of February, the Attorney General distanced herself from that. She issued a press release stating that in response to the Tuesday release, she said that she never, quote, never supported the governor's office decision to spike gubernatorial staffers' paychecks to symbolically repay illegal pay raises. Barrett Anderson's office issued a statement that the retroactive pay raise, which she publicly determined as illegal on December the 10th, 2015 memo to the governor, quote, can only be resolved through repayment of the retroactive pay adjustments by each individual employee or through legislative action. Though the AG's stance on the issue had already been publicized, Barrett Anderson issued her stance Tuesday after the governor's office made a recent comment. Governor's office spokesman Oya told Pacific Daily News Friday that even before Barrett Anderson issued the December 10th opinion, Barrett Anderson had been engaged in discussions with Adelup about the retroactive pay. Oya said that these steps had been taken to address the raises based on those discussions with Barrett Anderson. On Tuesday, Oya clarified that the governor's office understood the Attorney General had problems with the pay raise process, quote unquote, and that the office went about correcting the problem. Quote, we fixed it the way we thought we needed to. She didn't tell us how to fix it, quote. Oya later added that the governor's office corrected the problem, quote, in a way that we thought was appropriate to address the concerns of the process. Barrett Anderson stated in her opinion that the retroactive salaries violated anti-retroactive payments. And she suggested, but what many of you saw on social media was a screenshot of a couple of staffers of the governor's office. In one instance, one of the staffers was to have received or performed 72 hours on November the 28th. And his salary for that period was for those 72 hours, was supposed to be $306 an hour. And on that screenshot, it also shows that the very next day, the amount went down to $66 an hour, which is what his annual salary is. And what Bill 222 was to do was to not have these kind of spikes, that one day it would go up to $306 an hour for 72 hours, and then go back down the very next day to the regular salary. What 222 wanted to do was acknowledge the governor has the authority to pay his staff whatever he decides to do. When we did the budget, Madam Speaker, the first thing I told the OFB staff was take out the provisions for tax refund, take out all of the amounts that you needed to pay back all the bonds, and then take out the amount that the governor asked for in his budget for his office. If you look at the executive budget that was presented last January and the budget that was passed in August, the amount for the executive office at Adelup for the governor and lieutenant governor is exactly the same to the penny. I instructed the staff, in recognition of the fact that we have 3 separate co-equal branches of government, do not attempt to touch the governor's office budget. And so it went through just the way that it was. With the judiciary, unfortunately, it was off by about $100,000. And subsequent to the budget, I got criticized as they were my favorite because I gave them as much money as they did. But I was recognizing the fact that we have 3 co-equal branches of government. In 222, I also recognize that the governor has the authority to pay his staff whatever salary he wants. But all that I asked for in 222 was that any salary that he pays is to be paid in 26 equal biweekly payments. Not to have on November 28th a spike with 72 hours worked in a 24-hour workday for $366 an hour, and then the next day it drops to $66 an hour. That was what I was trying to prevent. And I know many people didn't believe that that was going to happen, but it did happen. And someone who had access to the personnel AS400 was able to leak that. Fortunate, unfortunate, there are government employees who do not want to be part of this and have leaked it to the media. It wasn't my office. We don't have access to that area of the AS400. But it has since come to light that it happened. And that's what 222 is trying to prevent. He can pay them whatever he wants, but pay it over 26 bi-weekly installments. Not a spike for one day of 72 hours, but 26 equal biweekly payments. And so we've seen that everything that I talked about that could or might happen in an attempt to try to address this issue did happen. And the only way that we can protect against this, Madam Speaker, is to make sure that this legislature stands firm in its vote that we had last month on 222, and that we tell the governor we respect and accord you the power of being able to set the salaries of your staff, but when you do it, please do whatever salary that you're going to pay in 26 bi-weekly equal installments, not in one spike on the 28th of November of 72 hours at $306 and then back down to $66, and then to pay it out on December the 12th. And if you look at that screenshot, it also says it's retroactive pay. And the reason why the Attorney General had to distance herself from the comment that the Governor's office made was that there is a code of professional responsibility that all attorneys must adhere to. And let me just read it. A lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent. But a lawyer may discuss the legal consequences of any proposed course of conduct with a client and may counsel or assist the client to make a good faith effort to determine the validity, scope, and meaning of the application of the law. And she had counseled them about the fact that this scheme was not legal because it was going to be another retroactive pay. And the fact that it's retroactive is shown by the fact that when I FOIA'd the governor's office for the personnel actions or the GG1 that they used for this, it was dated, it was signed by the chief of staff and certified by the deputy for the pay period December 7th to December the 12th, and attached all 70 employees of the governor's office that were going to get the retro pay, that reimbursement check. But the work had already been done on November the 28th, almost 2 weeks before, over 2 weeks before what they were asking for in the GG1. I thought that what they were going to do was to ask for that 40-hour pay period, that in that 40-hour pay period that they be paid, divide 40 hours into the 24,000, about $600 an hour. No, it was 72 hours at $366 an hour. I mean, that was even more of a spike than I had anticipated. And so we really must, Madam Speaker, in order to protect the integrity of the budget system, the integrity of the authorization of the appropriations that come out of this body, and to protect the governor's office and his staffers from committing these offenses. If it wasn't clear, 222 makes it clear what you can do. So there's absolutely no gray. It's absolutely clear. No retroactive pay, no bonuses, and if you're going to do anything, make it 26 pay periods. Because it really is a shame that so many people are going to be hurt by this action that was done. And actually, I don't understand why they just didn't come to us. In December 2014, I bet that if they had asked us to include the governor's office staff and the OPA that had been left out in 32208, there would have been somebody here that would have introduced it. I know that a number of you members in here were going to introduce legislation to put the OPA back in, who had been neglected in the bill that had been sent down by Adelup. And if they had asked for the 107 employees of the governor's office, I would bet somebody would have championed it, and I think it would have passed. Unfortunately, it was never authorized by this legislature, and it probably could have if it was asked for ahead of time in December 2014, January 2014, or even February 2014, when there was still a love fest between the two, and we were getting $700,000, which is now being taken back. We probably would have approved, authorized the pay for the 107 staffers. But this legislature could not be asked, as was recommended in the AG's opinion on December 10th of 2015, that we go back and we make legal something that she had determined to be illegal. It was too late at that point. She had determined it to be illegal. If we had acted before she opined that it was illegal, then we could have said that we were just trying to correct an oversight. But for us to address the issue after her opinion came down would have been to legalize what she had already determined to be illegal. It really should have been done earlier. Unfortunately, all of these things have happened, and the only way to protect against it in the future for any future governor is to make sure that Bill 222 is overridden despite the objection of the governor. Thank you very much, Madam Speaker, and I really do hope that my colleagues will stay with me, the 13 that voted with me in the last time will stay and override this, and I'm hoping that the events of the last month will convince the other 2 members who did not vote for the bill the first time to realize that it really is imperative that we give explicit instructions to the governor's office about what it can and cannot do. And I'm hoping that we have a 15 unanimous override of Bill 222. Thank you very much, Madam Speaker.
You're welcome. On the motion, notwithstanding the objections of Magalahi and Guahan, to place vetoed Bill 222 in the voting file for an override. Any discussion by any members? There being none, okay, so then the vetoed bill is on the voting file. So then once it's on the voting file, then we would take then the vote. Right, so we are then, so it's go ahead.
Madam Speaker, given what you just said, then notwithstanding the House rules, I move that we go to the voting file to vote specifically on whether or not the bill should be
For
overridden.
the override here. Okay, would the clerk please take roll call? I don't have the title. Yeah, the title. You have the title. Oh, just the. Yeah, it is. So you're going to read the title. So the question then for everyone, of course, is shall the bill, which is Bill 222, notwithstanding the objections of Magalahi and Guahan, pass? And then the vote will be a roll call vote, and your response, of course, will be yes or no. Okay? So go ahead and just read the title, just the title.
An act to amend Section 6, Bill number 222-33 COR, as substituted by the Committee on Appropriations and Adjudication, and further substituted and amended on the floor. Introduced by B.J.F. Cruz. An act to amend Sections 6207 and 6207.1, and to add new sections 6218.2 and 6218.3 of Article 2, Chapter 6 of Title 4, Guam Code Annotated, relative to prohibiting bonus pay and mandating proper pay and pay adjustments processing for unclassified employees of the government of Guam.
Roll call.
Senator Tom Atta. Yes. Senator Tom Atta, aye. Senator Tony Atta.
Good morning. No.
Senator Tony Atta, nay. Senator Uggan. Yes. Senator Uggan, aye. Senator Blas. No. Senator Blas, nay. Vice Speaker Cruz.
Aye.
Vice Speaker Cruz, aye. Senator Espaldon. Yes. Senator Espaldon, aye. Senator McCready. No. Senator McCready, nay. Senator Morrison. Senator Morrison, pass. Senator Munya Barnes. Senator Munya Barnes, aye. Senator Respicio. Senator Respicio, aye. Senator Rodriguez. Senator Rodriguez, aye. Senator Sinicholas. Yes. Senator Sinicholas, aye. Senator Torres. Yes. Senator Torres, aye. Senator Underwood. Yes. Senator Underwood, aye. Speaker Wampat.
Come again.
Speaker Wampat, aye. Senator Morrison. Senator Morrison, pass. Senator Morrison. Senator Morrison, aye.
On the matter of vetoed Bill number 222, notwithstanding the objections of Magalahin Guahan, the votes are 12 yeas, 3 nays. Bill number 222 is overridden by Iminat 33 na Legislature in Guahan. Senator Espicio, you recognize.
Thank you, Madam Speaker. Notwithstanding the House rules, I move that we revert back to motions.
On that motion, without any objections or order. Senator Underwood, you're recognized.
Thank you, Madam Speaker. Madam Speaker, notwithstanding the objections by the Magalahin Guahan, I move to override the veto of Bill 204-33
And place it on the voting file.
and to place it under voting file.
Okay. So, and you would like to speak.
Yes, and may I ask that I be given the opportunity to say a few words?
You may proceed.
Thank you. Madam Speaker, this is not just about saving money, and this is not just about directing our funds to our priorities. These are important enough reasons for us to override the governor's veto. But we are at a juncture, Madam Speaker, where the public confidence in our ability, in our capacity to do the right thing has reached its lowest point in this decade and maybe in this century, maybe ever in the Guam's short history under the Organic Act. When we give ourselves pay raises in a lame duck session, it is clear that only lame legislation can emerge. Lame duck sessions are reserved for pro forma business or real emergencies, not a time to give ourselves a Christmas gift just because Christmas is a few weeks away. I don't doubt that many of our directors deserve more. I don't doubt that many of our mayors work long hours and deserve more pay. I don't even doubt that the governor and lieutenant governor and the members of this legislature work hard and that we deserve additional compensation. But this is not just about what we deserve, Madam Speaker. This is about leadership, the courage to lead, the courage to say things cannot go along as usual, the courage to listen to our community, the courage to say that enough is enough. We live in a democratic society, an imperfect one, but based on democratic principles nonetheless. In a time like this, I am reminded, Madam Speaker, of the words that President John F. Kennedy had stated, and he said, "Democracy is never a final achievement. It is a call to effort, to sacrifice, and a willingness to live and die in its defense." On a small scale, here in Guam, we in this legislature are the soldiers of this democracy. We are the ones who should have the courage to say what we know in our heart is an inconvenient truth. The public doesn't like this. Our constituents have spoken to us clearly. The government cannot afford it. The children, the sick, the victims of crime need it more than we do. So I now humbly ask my colleagues to vote in favor of Bill 20433 to override the governor's veto, and please to vote based on what your conscience tells you to do. Thank you, Madam Speaker.
You're welcome, Senator. Senator Espicio? So motion, okay. So we're then on that motion then for it to go down to the third reading, to the voting file. Any discussion? None? Okay, so it is then, there's no objection for it going down to the voting file. So ordered. And Senator Espicio?
Thank you, Madam Speaker. Notwithstanding the House rules, I move that we go to the voting file for purposes of voting solely on the override attempt for Bill 204.
Thank you. So can the clerks please read the title?
Bill number 204-33 COR, introduced by Michael F.Q. Siniclas, Judith T. Wampet, EDD, N.B. Underwood, Ph.D., B.J.F. Cruz, T. Seata, an act to add a new Section 1106A to Chapter 1 of Title 2 Guam Code Annotated, and to amend Section 40109A of Chapter 40 of Title 5 Guam Code Annotated, relative to reducing the compensation of elected and appointed officials.
So the question, of course, to everyone is that shall then vetoed Bill number 204 pass, notwithstanding the objections of Magatlahi and Guahan. So the clerk, please call for the vote.
Senator Tom Atta. Yes. Senator Tom Atta, aye. Senator Tony Atta. No. Senator Tony Atta, nay. Senator Uggan. Yes. Senator Uggan, aye. Senator Blas. No. Senator Blas, nay. Vice Speaker Cruz. Aye. Vice Speaker Cruz, aye. Senator Espaldon. Yes. Senator Espaldon, aye. Senator McCready. No. Senator McCready, nay. Senator Morrison. Nay. Senator Morrison, nay. Senator Munya Barnes. Senator Munya Barnes, nay. Senator Respicio. Senator Respicio, aye. Senator Rodriguez. Senator Rodriguez, nay. Senator Siniclas. Yes. Senator Siniclas, aye. Senator Torres. Senator Torres, aye. Senator Underwood. Senator Underwood, aye. Speaker Wampat.
I'm good.
Speaker Wampat, aye.
On the matter of vetoed Bill number 204, notwithstanding the objections of the Magatlahi and Guahan, the votes are 9 yeas, 6 nays. Bill number 204 fails to get the required vote to be overwritten. Senator Espicio, you recognize.
Thank you, Madam Speaker. Notwithstanding the House rules, I move that we revert back to the second reading file.
There are no objections, so ordered. Okay, we're back to second reading file, and we are going back again to the very front, which is bill number 89. Oh, Senator, Mr. Vice Speaker?
When we broke on Bill 89, I believe the floor, Senator Underwood had the floor and had introduced an amendment that Senator Bloss had some question about, and I believe, Senator Underwood, you have an amendment? Well, there was the question of the, Senator Underwood had, and you had been in the discussion about good moral character. And so I believe she has an amendment. Is that correct?
Yes.
Please.
Thank
Has
you,
it been circulated?
Yes, it has been.
Okay. Please, you
Okay.
recognize Senator Underwood.
Thank you. Thank you, Mr. Speaker. I believe everyone has a copy of the amendment, and basically, if you go to page 2, under 4, it would read, at least one remaining board member shall come from the public at large, and the rest of that sentence will be stricken out. And to add and number 5 would be, all board members shall be of good moral character.
Does everybody understand that amendment? It's to add, make sure that there's a 5th requirement, and that applies to all the categories above, to make sure that it's clear. Senator Bloss, you
Thank you, Mr. Speaker. Mr. Speaker, just to reiterate my concern with regards to using that language, good moral character, that's subjective. And I remember several years ago we had the same conversation with regards to, what that meant for a member of this body. Moral turpitude, remember that conversation? And so we would hope, and I think common sense would basically suggest that when you're looking for individuals to serve in the capacity in this board, that good moral character is given, for that matter, for lack of a... And so for us to be able to say that it's necessary, it's implied that it's necessary already. I just don't want to get into this whole issue with regards to then what the definition is of that. Because we can have a whole conference. I think, the legal system has a whole conference on trying to define, moral standards. And so to put this here is just going to, we just may be going down a road that it's unnecessary. And so my suggestion is just take that language out.
The only problem that we have, Senator Bloss, is that under statutory construction, the current statute has that under 4. And then to strike it might mean that this legislature does not deem good moral character as is necessary.
I understand. Again, this was the discussion here, and, I just concerned that we're going to get now because it's there. This gives us the opportunity to be able to fix things, okay, that probably have been in existence for so long and not necessary. And this is that opportunity. And so with that, I proffer that suggestion. That it should be that standard already. It should be given, implied. Not to say, I don't want to say that I object to the whole thing. It's just that it's implied.
No, I understand. It's just statutory construction leaves us, it'd be more vulnerable, that it'd be an easier discussion to say the legislature never intended good moral character because it struck it. Okay. Okay. Thank you very much. On the, any other senator wish to be heard on the Underwood Amendment? Senator McCready, did you say the good moral character amendment? Okay. On the Underwood Amendment, any objection? We're back to your amendment. Please.
Thank you, Mr. Speaker. We're passing out my proposed amendment, and after consulting with the proffer of the amendment and the author of the bill, I would like to now add an amendment to the amendment, and it's pretty simple. On line 22, page 2 of the bill, section 1, at least one person, we struck out the two. On the second item, at least one person, we struck out the two. And on the third item, at least one person. And we took those three people and we made it on line 4, at least 4 remaining board members shall come from the public at large and be of good moral character and shall be chosen by Magalahenguahan.
All right.
So I just added your amendment already, thinking that it would pass.
How about here? Let's take a few minutes. After consulting legal counsel, the decision was to divide the amendment, and so we'll do them seriatim. Go ahead.
Thank you, Mr. Speaker. So I'd like to proffer the First Amendment, which would be on line 22, page 2 of the bill, section 1. We change it from 2 board members to at least 1.
On that amendment? Your second amendment, Senator?
On section 2, we change it from 2 board members to at least 1.
Any objection? Your third amendment?
The third amendment would be to change 3 remaining board members to at least 1. Bless you.
All right. Any objection? Yeah, we did, and we are. All right, so the third one was in subsection 3 to at least 1.
Yes.
Do you have a second amendment on that subsection 3?
And my fourth amendment, Madam Speaker, Mr. Speaker, is would be the remaining, at least 4 remaining board members shall come from the public at large, period.
On that amendment, Senator Espaldon.
Thank you, Mr. Speaker. I just want to clarify, does that mean he's deleting the words "and be of good moral character and shall be chosen by Imagalahi"?
That was already approved.
Okay.
This is just adding it to hers.
So I don't need to put it in mine. I accidentally was this added? I added it, so now I have to take it out because her amendment was to delete.
Senator Underwood's is on 5, not on 4.
So I would basically be taking out her amendment.
Senator Espaldon.
Thank you, Mr. Speaker. Mr. Speaker, I realize that this amendment, that amendment was made previous, and I was out of the session hall, that included the words "good moral character."
Yeah, that's 5.
Oh, that would be 5.
Yeah.
Is that to come, or is that already?
No,
been
it
discussed?
was already done.
Well, if I may, since it's in this amendment also, and it stays in here, if I may.
He realizes it's duplicative, and so he's striking it from his, and he's just saying, and there'll be 4 from the public at large. Period.
Okay, so the amendment is just to make it 4 as opposed
Yes.
to 1.
You're right.
Okay, and the point, Mr. Speaker, I just wanted to make is that good moral character, and I realize, and I apologize for not being here, and I may have missed the boat on this one, but good moral character is not defined anywhere within our laws. There is a moral turpitude that is in the law, but good moral character, if we really want to think about it, is more a subjective call than it is an objective call. And so, again, I would imagine that we might need to revisit that because, again, who is to determine what good moral character is subjectively and say that's the appropriate way to go? But I just want to make that point, and if possible, I'd like to come back and make an appointment, an amendment when we come back to that bill. Is that too late?
Well, no, it's in here as 5, but in a definition someplace in the code, if you want to introduce legislation to try to define it, you may.
I don't. Actually, what I'd like to do is try to make this more objective and just saying that essentially none of these board members shall have had shall have been convicted of a misdemeanor or felony, and that would be a more objective approach as opposed to a subjective approach in determining who should be sitting on this board.
Okay, and so what do you do with the striking of it in the current section 4 as statute? What statutory construction do with striking it for the 33rd Guam Legislature to strike of good moral character and no longer have it in the statute? How is that to be interpreted by the...
Mr. Speaker, my approach would be to strike that, and then to, instead of using good moral character as the basis, use and shall not have been convicted of a misdemeanor or felony, because that in itself is a very objective approach that we can ask, have you ever been convicted? Whereas we can never ask, are you of good moral character? Because again, it's not defined.
Okay. So you want to add on 5?
To amend the amendment, right?
No, that would be on 5.
Yeah, on 5, yes. But I might be out of order, Mr. Chair.
Well, not right now. Yes.
Okay. Thank you, Mr. Speaker. If I get an opportunity, I'd like to. If not, then I'll just concede to the will of the body. Thank you.
No. Okay. On the 4, any objection? Senator Espaldon, I will allow you to make an amendment to 5 if you wish.
Thank you, Mr. Speaker. On 5, it should be the words. I'm sorry. Let me just get the.
There should be a sheet with Senator Underwood's.
Right. It says all board members shall be of good moral character. It should be all board members shall not have been convicted of any misdemeanor or felony. And that would be a more objective approach in terms of who can sit on the board as opposed to good moral character, which is not defined anywhere in our code.
If you want to...
All board members shall not have been convicted of...
We'll take a short break.
Thank you for the brief timeout. I was able, in terms of being able to discuss with our colleagues on the floor the pros and cons, I would, at this point, Mr. Speaker, withdraw any amendment that I would make to this section. Thank you.
Thank you very much. On the main motion, Yeah. On the WAMPAT amendment as amended by Senator McCready and Underwood. Well, I don't know. He's Senator McCready? On the main amendment by WAMPAT with all of the amendments. On the main motion. Senator Egan, you may close.
Thank you very much. Mr. Speaker, I'd like to move for the placement of, or the inclusion of Madam Speaker Wampat and Senator McCready as co-sponsors of this particular legislation, please.
Underwood.
And the good Senator Underwood.
On that motion, no objections, order.
Thank you, Madam Speaker, and to everyone who has contributed to the deliberation and discussion of this legislation, thank you, because I believe that we've allowed a bit more expansive pool of candidates out there that hopefully the Chief Executive will be able to take advantage of this and add additional members to this board. Thank you very much, Madam Speaker.
You're welcome, Senators. On the motion to send 89-33 to the third reading file without any objections, so ordered. Bill number 149, Senator Tony Atta, you're recognized.
Thank you, Madam Speaker. Madam Speaker, we just set aside Bill 149 yesterday as a couple of my colleagues they didn't have the time to review the bill as I just substituted on the floor that morning. And I'm just ready to move down to the third reading file if they have no further questions or concerns.
Okay, and would you like to discuss the again, for just because we're now bringing it back again, so just briefly.
Thank you, Madam Speaker. Madam Speaker, Bill 149, as you know, as I stated yesterday, in all 50 states, the District of Columbia and American Samoa have all enacted statutory law that holds parents civilly liable for actual and tort damages for certain acts committed by their children. And the amounts of liability in other jurisdictions range from $1,000 as high as really unlimited. And while no state holds parents without complicity criminally liable for their children's crime, such laws will probably more than likely be unconstitutional. Enacting Bill 149-33 into law will follow the sentiments of the rest of the country that as a community, we all take our duties of parental responsibility seriously. And what we did is this bill is patterned after California's parental liability law. And it means that it'll be more costly if parents don't take their parental responsibility of their children. And also, in moving forward, back in September, when we had our public hearing, no one came out to testify. However, they did have written testimony from the Attorney General's office. And when the bill was reported out in October, I wasn't able to meet with her prior to the reporting of the bill out from the committee. And since then, I sat with the Attorney General on the substituted version of the bill, and she was amenable to the changes that were made there. So that is why we've taken since October of last year until just this past month where I introduced it to go onto the floor for voting. And her concerns were addressed in the substituted version of Bill 149, and I hope that we can move forward with this bill, and I'll be able to get my colleagues' support. Thank you.
You're welcome, Senator. On the motion, Senator Tom Atta, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I support the idea of having parents responsible for the actions of their minor children, which may result in the willful misconduct of a minor, which may result in an injury or destruction to property. The questions that I have, though, with the bill is that I notice, for example, in paragraph A on page 3 of the bill, when it comes to, as a result of the misconduct, it results in physical injury to a person, then the liability is limited to the medical, dental, and hospital expenses incurred by the injured person not to exceed $25,000. So then if let's say my child got bullied in school and got, really messed up, and all it required was a couple of stitches and whatnot, then we only the liability to the parents of that bully would only be the cost of the medical care. But of course, the way it's explained here is that the trauma that's inflicted upon that child is not taken into account. So it's basically show me the doctor's bill, and that's basically what you're going to be your liability. However, when we take a look at Section B, when it comes to that the misconduct results in the defacement of property, then there's no limitation that the liability is only for the cost of the paint and the materials that is needed to be able to correct whatever damage was done to the facility. But in addition, but instead, it just pretty much, hey, they can nail you for up to $25,000. But in addition to that, it allows for the inclusion of court costs and attorney's fees to the prevailing party, whereas for the parent of the child who got bullied, I guess it doesn't say here that parent can include the cost of attorney fees and whatnot. So somehow I think it sends the wrong message that, we're not putting as much focus on the physical injuries that are caused to another person as opposed to damages to property. And then on paragraph C, it talks about that the amounts listed in subdivision A and B, I guess that $25,000 threshold, may be adjusted every 2 years by the Judicial Council to reflect any increases in the cost of living in Guam. And somehow it just seems that, if then we have to resort to like every 2 years, let's go ahead and increase the penalty, then maybe the penalties is not serving its purpose. And maybe we need to look at why are these things continuing to happen despite the fact of that potential liability of upwards of $25,000. So I have the concerns with that, and so I don't have the language right now to make for the amendments to be made, but I do want to make my observations about the apparent imbalance between that liability for physical injury versus for damage to property, and that it seems that, this thing about coming back every 2 years to reflect any increases in the cost of living, I mean, if that's the case, might as well make the liability be, set the threshold at $100,000 and let the judge figure out what are the appropriate costs to be, the appropriate penalties to be assessed. So, those observations that I've made, I have serious concerns with, and admittedly, I don't have language to make the necessary amendments, but my observations stand nonetheless. Thank you.
We're going to take a brief recess. Senator, I know there are additional questions, so I'm going to ask that we set this aside. Thank you, Senator. 185, Senator Rodriguez, you're recognized.
Thank you. Good morning, Madam Speaker. Madam Speaker, move to place Bill 185 as substituted by the author and further substituted on the floor on the third reading.
And would you like to time to discuss?
Yes, ma'am, please.
Okay, you may proceed, Senator.
Thank you. Substitute Bill 185, Madam Speaker, has evolved considerably, and I believe quite fairly and reasonably since its introduction earlier or last year, or even from Bill 239-32, which I previously introduced in the 32nd Guam Legislature. While recognizing and facilitating the rights of the landowners to receive a legitimate opportunity to seek redress, Bill 185 nonetheless seeks to do so in a balanced process, pursuant to which the burden of proof is shared and is not simply and onerously left as a burden and loss to be borne solely by the landowner impacted by the inverse condemnation, while the government safely takes shelter behind a statute of limitations heavily tilted in favor of protecting the financial liability of the government. Madam Speaker, I would at this point bring your attention and consideration to a November 1992 audit report by the Office of Inspector General, U.S. Department of Interior, which is part of the committee report. At best, the report is a scathing indictment of the land-taking practices by the government of Guam, and even goes so far as to cite on page 18 the Inspector General's comments regarding our government's actions in the same paragraph, referencing the infamous land scam criminal cases and convictions of November 1990 regarding the attempted theft of government land. The 8 recommendations being referred to by the Inspector General pertain to needed corrections by our government, as was and is needed to implement policies to resolve its inappropriate practices relative land takings for easements. In a 1992 response from the government of Guam, that the 8 recommendations, and I quote, will eventually have to be accomplished, end quote, and added that identification of rights of way is necessary and must be accomplished. However, the response also stated that 1, the Department of Public Works is not prepared to perform the work required. Number 2, that efforts to identify rights of way would be massive and at a tremendous cost. Number 3, that the funding is limited and qualified appraisers are not available for the rights of way work. And number 4, the prescriptive rights is an emotional issue that will have far-reaching effects and will eventually be determined in court. The government response concluded that for these reasons, it will be fruitless for the government of Guam to comment on the 8 recommendations. In response to the foregoing response by the government of Guam, the report stated, the response, and I quote, the response is correct in stating that rectification of the rights of way problems will be costly and take substantial effort. However, the government of Guam should be acting to resolve the problem rather than disregarding the issue and waiting for the courts to rule, because rights of way acquisition costs will continue to escalate. Further, the government of Guam has vigorously prosecuted individuals who have attempted to take government land for their own use, as evidenced by the government's obtaining 3 convictions since November 1990 on the charges of attempted theft of government land, end quote. So, Madam Speaker, the glaring question left begging is, what are we as policymakers going to choose to do today, February 2016? Do we simply kick the can down the road once again to a time when landowners are perhaps going to be dead and their heirs no longer remember, or they see it all as even more useless exercise in futility? Or do we do what is right and finally address this important matter? The most important provision of Bill 185 is that it reopens the opportunity for landowners to seek due process and just compensation. Just as Chamorro landowners petitioned the U.S. Congress in the pursuit of the 1997 Omnibus Territories Act provision authorizing the seeking of land claims. Our Chamorros had to actually obtain permission from Congress to sue the U.S. government. Is now our legislative body going to now say no and leave the existing and extremely unfair and unbalanced process in place? I would hope not, Madam Speaker, and at the very least, we should be very clear in letting landowners know where we stand, without espousing profuse political jargon and clouding the true nature of our failure as a government to act in a beneficial manner for the landowners. The second and another extremely important provision pertains to the sharing of the burden of proof between the government agencies which have expropriated the lands through inverse condemnation and the landowner who, under current law, is at a disadvantage, most of whom have already lost their struggle by default due to their inability to meaningfully participate in the legal process, which are part and parcel to the government land-taking process. By dragging its feet, the government today receives a get-out-of-debt-free card. This version of Bill 185 would additionally establish an expedited administrative process. The third provision pertains to the establishment of efficient judicial process dedicated to land issues and pursuant to which timely access may be had before the judiciary of Guam. Under the current system, it can take years to schedule a land case on the court dockets. They simply do not receive any priority consideration as compared to other types of cases before designated courts of record. We work very closely with the Judiciary of Guam and the recommendations as to the provisions in Bill 185 pertaining to the establishment of a dedicated land court. The Attorney General of Guam has also favorably received the establishment of this land court. I must admit, Madam Speaker, and be very transparent, that there is a significant cost involved in addressing this issue, just as with any other legitimate public debt we have accrued, and ultimately have historically had to pay upwards of hundreds of millions of dollars to resolve. However, just because in all likelihood this will be expensive does not make it any less necessary, nor does it justify not addressing it. Because of the collective beneficial outcome derived, we cannot allow the burden realized to be placed solely on the backs of a few. This is a collective public burden, the cost of which must be shared equally. As to putting an exact dollar figure on the financial exposure and obligation of the government in resolving the outstanding compensation obligations due the affected landowners, the only documented study available providing any reasonable estimate is found in the same audit report that I referenced earlier by the Office of Inspector General, U.S. Department of Interior. This outdated study, Madam Speaker, would have already set the estimated cost upwards of $108.7 million as of 1989, with an additional estimated late acquisition cost of $74.3 million as of the year 1992. The estimate provides a market value adjustment between 1987 and 1989, during which time Guam land prices jumped upwards by 313%, but remained steady through 1992. And the liability figure will have risen further due to additional land takings since that date. Add to that the cost of interest on the fair market value due to the owner at the time of taking, which will have continued to accrue since the date cited in the Inspector General's report. This version of Bill 185 recognizes that this government is responsible for this debt and sets up a mechanism to manage this process by setting up parameters that trigger a request for legislative authorization and appropriation when settlements are reached with landowners. The bill establishes a land claims compensation fund that will be used to pay in whole or in part settlements to landowners whose land's been taken by the government. It requires an annual appropriation to the fund, beginning with a very, very modest amount of $500,000 beginning in FY 2017. In addition, I believe, and I believe a contention for some, Madam Speaker, will direct deposits of funds derived from the payment in lieu of taxes, commonly known as pilot, into the Land Compensation Fund. Madam Speaker, in 1986, the 18th Guam Legislature enacted Public Law 18-15 that included a provision requiring public utility agencies to make payment to the government in lieu of taxes. The theory of the law is that non-tax-paying utilities benefit from services provided by the general fund, such as police and fire protection, road systems, and other government facilities. Rather than assessing a tax on them, a fund transfer policy was instituted. Moreover, and to bring in context the rationale behind diverting these funds to the Land Compensation Fund, historic data and information points to the utilities as one of the government entities who have inversely condemned private property for public use without due process. Despite this 30-year pilot law being in place, it hasn't been enforced, nor has there been any attempt by this or prior legislatures to repeal it. If it was a desire to not pursue this, Madam Speaker, there sure wasn't any policy call made from this body. In 2011, when the Calvo-Tenorio administration first came in, Madam Speaker, a DOA started to look at this law and started to bill at least one of the utilities, GPA. And the bill that they were trying to pursue at that time was about $12.5 million, covering a period of 14 years. There was discussions between GPA and the administration, and so a proposed settlement was reached for $2.6 million for those years and an annual transfer of $875,000 thereafter for that one entity alone. That proposed settlement has been tabled by the PUC because GPA was supposed to do several actions before going back to PUC to have it approved. However, that hasn't taken place. And so, Madam Speaker, all this bill does is direct these funds, when collected by the government, for this effort. Unless there is an effort to repeal Public Law 18-15 in its entirety, this is an obligation of the utilities, and it is something that is collectible. Madam Speaker, the people of Guam have experienced a long, complicated history of unfair land taking and denial of due process. We have experienced this from both the federal government and now our own government of Guam. This history has left us with a stronger determination that any land takings without any measure of justice and equity are not to be tolerated. And so, Madam Speaker, I asked you and my colleagues for their support on this measure. We've attempted last term to address this. However, it's a very big matter that involves a lot of components, and so we deferred it. I reintroduced it this year. It went through a public hearing. The good chairman who had oversight, Senator Uggan, had conducted several markup meetings after that public hearing with parties who had some concern. And so we feel that we have addressed most of those concerns, if not all. This is the second time. This is an attempt to move it through this legislative process. We had it a session or two ago. There was some concerns, and so we did bring it back. So this time, Madam Speaker, we're hoping that our colleagues can support this and move this forward so that we can start seeing some resolutions to these injustice that our people have suffered. Thank you very much, Madam Speaker.
You're welcome, Senator. On the motion, does anybody would like to speak on the main motion? Senator Tom Ada, you're recognized.
Madam Speaker. Madam Speaker, supportisti na idea ni para terspia empenyo ni tamano para ta aposid siya i man maamot ni tanunia por rason na po manaholo mitsalan pat poro managwaha easement ni paro na falofan i todo siya i trustees GPA dan i GWA sa debia magait na fan maaposis na tawtawgi siya no i mapropone gini na bill ni tamano para pamamaneha mo nasti para taatan haji nu gaitanu matsuli za kwantu dipusi pofan maaposi nu malik taza magai nu ti sathina suzo nu put tamanu ni para tamane para mona ni para tahutso mistina hagasa ma nu gaigi hujung gini ni tabiati ma address nu una magai nu muna kalan nu mustot bazo gi istigini gi pahinan 11 gi section 6 gi maproponi gi lai na salapi malik na idea ni planea ni tamanu mona para ta sogwiste lo janggen matut gina punto sa madititmina na magahit matsuli los prohimo tanotnya mano na para ta sudai salapi ni para ta aposis ti na dueño no lekuna taza gi salapi pues los óptimos kalanta hatsay hafanu expectations ni tau tagi hujung na estige pago pero finamalik edzi matsuli tano lo lesottomos angin manmatut gina punto tasoda na taza salapi. Madam Speaker, I support the idea behind the bill, and I think that the work that has gone into laying out the procedure and the process as to how who would have the responsibility for determining whose land was taken and who needs to be compensated, I think is fine. I have no problem with that. Where I have a problem is once we get to that point then when we have settled all that, identifying whose land was taken, how much is the compensation and all that, we're going to find that the source of funding as stipulated in Section 6, the money's not going to be there. The author did accurately explain that this autonomous agency revenues or the autonomous agency collections fund, which was otherwise commonly known as the pilot payment in lieu of taxes, was actually enacted 30 years ago. And it was, when it was enacted, I believe it was only the port, the commercial port, that had actually paid $1 million to the administration, paid in. But after that, nobody else paid. And so when the current administration came in, they sat down and they said, they sent a bill to, they started out with the Guam Power Authority and said, you owe us $12 million. And the Guam Power Authority immediately said, okay, this is an added expense to our operations, and the only way that we're going to be able to meet this obligation is to go to the Public Utilities Commission to petition for a rate increase. And at that time, they came to the point where they determined that in order to pay for that $12 million that they're being invoiced, I believe the GPA ratepayers were going to have to pay an additional $2 and plus for a number of months to be able to pay off that $12 million. And then after that, would have to pay an additional something like 52 cents additional on top of their bill for an average customer who uses 1,000 kilowatts to be able to meet the continuing obligation ad infinitum. But I guess when everybody realized that when you try to collect these from the autonomous agencies, it isn't as if they have this pot of money that's just sitting there waiting to get appropriated. And so in the case of the Guam Power Authority, they says, fine, this is an extra expense. They went to the PUC, and if you want us to really pay that, we're going to have to increase the power rates. The bill now adds the Guam Water Works to that list of agencies. When the public law was actually passed 30 years ago, Guam Water Works was not yet an autonomous agency, and so did not the pilot was actually not applicable to them, but now it's being included in there. So obviously, GWA is going to do the same thing. They're going to run to the PUC, and they're going to ask for an increase in the water rates. And so we're really just, it isn't as if, so in effect, if we're going to use this as the source of funding, we're going to end up charging again an additional amount to the water customers, the power customers. We're including in there the Guam, the commercial port, that they're going to do the same thing. And in the case of the airport, well, they're going to need to do the same thing also. So, in essence, we don't want to say that we're going to increase the tax to the people. That's not where we're going to get the money from to pay for the land that was condemned in order to put roads in. Instead, we're going to get it from the autonomous agencies, from this surcharge, this payment in lieu of taxes. It's a nicer way, a more palatable way of, saying tax. It doesn't come across as too much in your face, but you can call it tomato, you can call it tomato. It's still that red thing. And so I'm afraid that when we get there and we've done all the sorting out of who's owed what, we're going to find that we don't have the funds, or at least the funding source is really, I would call it a phantom source, and so we have unnecessarily raised expectations of those people whose lands were taken away. That's not to say that they shouldn't be compensated. I'm just saying that the source of funding for the compensation is really a phantom's funding source. Thank you very much, Madam Speaker.
You're welcome, Senator. On the motion, main motion, Mr. Vice Speaker. And then I also have Senator San Nicolas. Is there anybody else? Please indicate who else is interested in speaking.
Thank you very much, Madam Speaker. Madam Speaker, I understand the need for this bill, and I think it's laudatory. The unfortunate thing is the cost, as was stated by Interior in 20 years ago. It would cost $70 million, I believe. I think that it could possibly, at this point, be anywhere from $750 to $1 billion. Madam Speaker, the retiring speaker talked about the pilot program. There is another provision in law that wasn't anticipated in this legislation, but is affected by it. And it is, and we've seen the effect of it most recently in Luzon. On Chapter 38 of the of 11 GCA, there is a chapter entitled Acquisition of Privately Owned Lands, and it reads as follows. Notwithstanding any law or rules and regulations to the contrary, when the government of Guam cannot make cash payments for the acquisition of privately owned lands due to the unavailability of funds or for any other reason, the owner of such real property acquired by the government may elect to receive tax credits in lieu of cash on any taxes except income taxes payable to the government in the amount equivalent to the cash compensation of the property. A couple of years ago, we realized that after the condemnation of the eminent domain and condemnation of the land for Luzon, what we thought was going to be a $3 million obligation turned out, in fact, to be a $26 million obligation and 6% interest. Very easy math, trying to figure out with 25 million what the if you didn't cash in on it and just lived off the interest, you could have a very substantial retirement for the rest of your life, just living off the interest of 6% off 26 million. We've addressed the pilot. I really do think that we have to address this. And so, and at various times in the past, the OPA has cautioned and advised the legislature to please repeal the tax credit provisions that we have in the law. The tax credit provisions that we have in the law. Because it's impossible to determine what the obligation is going to be, and it's impossible to determine where it's going to be taken and when it's going to be taken. If, in fact, $750 million is the judgment of the court in the various provisions, it can be taken and in tax credits, and that'll be the new source of currency on island, of buying and selling the tax credits that you have. I do not envy the person that's going to be the appropriations chair at that time. And so my first amendment, Madam Speaker, has been circulated, and it would add a new Section 9 that would repeal the tax credit provision, tax credit in lieu of cash payments for property taken that's currently contained in 11 GCA Chapter 38.
On the amendment, Senator Rodriguez.
Thank you very much, Madam Speaker. And thank you also to the previous speaker. He brought up an example of the Luzon issue, and that, Madam Speaker, really is a glaring example of what we have to deal with. When we know the history of that of the Luzon deal, but you see the inequity when you have those landowners who were given the ability for the government to make right what they felt that the government wronged them with the taking of that land. What about the Tan Maria and the Tun Jose's? Are landowners whose lands were taken but don't have the means to fight it, don't have the means to bring it up to the government the way it's set out now in statute, that and say that, look, this is was done to us, this the injustice done to us, and we need to be compensated. So that example really just highlighted the need for us to be able to move this legislation forward. In terms of the amendment, I don't oppose it. I hear the Vice Speaker. I know that this was something that was also discussed during that whole Luzon issue. I just, I'm thinking, this is something that maybe should be done separately in another piece of legislation, and I would support it then as well. I just, not knowing what is in play now, perhaps what landowners and the government are working on now, I just don't think that, I just don't want this to be a factor in perhaps seeing a veto of this legislation moving forward. So, I'll wait for any other discussion on that, but this is something I support, but perhaps we can consider doing it as a standalone, separate piece of legislation.
On the amendment, is there anyone else who would like to have an opportunity to speak? Mr. Vice, okay, Senator San Nicolas.
Thank you, Madam Speaker. I just wanted to rise in support of the amendment. If we're going to be entertaining this legislation that's going to provide for a specific adjudication process for land claims, then we shouldn't have two existing processes on the books for one group to be able to get redress through one mechanism and another to be able to get theirs through something separately. So if we're going to change the adjudication process by which we're going to be addressing these land claims, then we should, if we're turning on one spigot or opening up one door, make sure we close off the pre-existing one. The Vice Speaker brought a very good point about how the Luzon tax credit question turned a $3 million liability into a $26 million liability. That's something also, Madam Speaker, that we need to be very mindful of as we discuss this legislation, because it didn't take a very big effort on the part of the government to create an environment by which the people of Guam, the taxpayers, were left with a liability that was almost 10 times more than what it was originally projected to be. And so as we work on building out this due process for these land claims, we need to be very mindful of how it could possibly be, turn out in a way that is of even greater consequence to the taxpayer. And we need to be mindful of the fact that in the end, when we talk about compensating for these things, it's not some magical sum of money that's going to come out of nowhere. It's coming out of the pockets of the people of Guam. It's coming out of the taxpayers. So we need to keep all those things factored in when we evaluate this. And tax credits right now, in lieu of cash payments for these properties, creates a lot of havoc for the budget process, because these tax credits go into the system and they impact in very particular ways that are oftentimes not really regarded. So with respect to this amendment, I rise in full support of it in the context of this bill, because then we're looking at the complete picture of how land claims are adjudicated and how they are compensated, and with respect to not only the new mechanism that will be established by this legislation, but the existing mechanism that will be repealed by this amendment. Thank you, Madam Speaker.
You're welcome. On the amendment, is there anybody else? Mr. Vice Speaker, would you like to close?
Thank you very much, Madam Speaker. Madam Speaker, when I rose to make this amendment, I was not stating any objection to the rest of the bill in the process. I applaud the author and the chairman of the committee for the round tables that they had with the judiciary and the Attorney General's office in trying to work out the process. I just most recently saw the effect on the budget process of Chapter 38, its application, and that was only $25 million. I can't even conceive of thinking that there's $750 million of tax credits out there that's being bought and sold. We saw that when we were doing the Lola Cola, that some of the people who could not afford to wait for cash were selling their tax credits at half the amount that they had received for the amounts that they were due. And so I don't know how much that's going to impact the budget. Is it going to be 750? Is it going to be 350? Is it going to be in healthy futures funds because it's going to be sold to tobacco companies? Is it going to be or sold to alcohol companies? Is it going to be in somebody's gross receipts tax, or is it going to be taken out in hotel occupancy taxes, which will kill TAF? It's impossible to tell because the statute says anything but income tax. So I just thought it responsible as Appropriations Chair to bring this forward and say, this has to be addressed because there is a statute that says once this passes and the first case comes through the process and they're owed a certain amount and there is no cash for it, they can, under Chapter 38, go and get a tax credit pursuant to this chapter. If they are a large enough landowner and they can use it for their own taxes, great. Otherwise, it may go on the market as a means of currency exchange on this island, and it'll affect the every budget going forward for the foreseeable future. And I don't know how we're going to be able to project revenue when we don't know how much is going to come in on tap, because we don't know if it's going to be against that. How much is going to be in the Health Futures Fund because we don't know if it's going to come in there. How much is going to be in TEF because it might be property taxes. And we have, for 8 years now, ignored the counsel of the OPA that we've got to do something about tax credits, because we should have the money and appropriate it where we think it should be appropriated. We shouldn't have tax credits and have a third party out there determined that I have huge tracts of other land and I'm going to take it out in my TEF and short education. I have hotels, and so I'm going to take it against TAF. I wouldn't know how to project. Thank you.
You're welcome. So is there any objections to the amendment? Hearing none, so ordered. Yes, Senator?
Point of information. Earlier, Senator Ada had, when he was discussing and speaking on the pilot, he was correct that the Guam Waterworks was not included in the initial statute. And so if we look at the substitute version that was reported out of committee, it didn't have it, but however, this version did include it, and so that was a mistake. And so I want to ensure that we remove Guam Waterworks Authority from that section, which is page 11, line 19. So that section will just mirror what the existing statute is from Public Law 18-15. So we can just
on page 11, line 19, delete Guam Waterworks.
That's correct.
Because it's not part of
the original
initial
statute.
Okay.
Yes.
Okay.
Just a point of information while we're pointing out information.
Wait, can I just do that? I'm so sorry. So I just want to make sure first that everyone understands that, and I gavel it in. There's no objection to that, to make that correction then? Well, yes, I realize that, but is it on this subject in the waterworks? Oh, okay, then go ahead. You're right. I thought you were going to talk about.
Well,
something
actually, I
else.
have 2 points. One was the author of the bill indicated that this legislature has never attempted to repeal the pilot law, whereas in fact it did with Bill 52-32. That was back in February of 2013, and it never made it past this legislature. I think it did not. It failed to get the 8 votes. The second thing is that I was looking through the committee report, and I noticed that the agencies from which we were going to, these payment in lieu of taxes comes from, were not present at the public hearing, nor did they provide testimonies. Maybe circumstances have changed since the last time, since 2011, when they went to the PUC and explained their situation. Maybe circumstances have changed such that maybe the source of funding is in fact viable, but it's notable that the autonomous agencies were not present to testify. Thank you.
Well, okay then. I just wanted to first of all just clear this part about what's not in the law to make sure first
Okay,
of all.
so we can do that
That's
first.
what I wanted to do, not so much that it's going to affect a change in what you had originally had stated. So, just for clerical purposes, that in terms of page 11, line 19, that Guam Water Works Authority be deleted here because it was not in the original law. Okay, is that understood by everybody now? Yeah, we're deleting it here because it's not in the original. In the original law is what you're talking about, Senator Rodriguez? Okay. I just want to make sure legal counsel are you okay with it? All right, then. And Senator, yes, you wanted to. And then, and if I can, then after this, I'm going to do a recess until this afternoon, then we can continue again. If anyone else, because I do have Senator Nicholas on the list to speak, and if anybody else would like to as well this afternoon at 2. So, Senator, go ahead.
Great. Thank you very much, Madam Speaker. Thank you for our colleagues for their participation. Just wanted to direct the body to PUC GPA docket 11-08, and that's really where the where we've gotten information regarding the proposed settlement between the government and GPA. And I know that the good senator from Manguilao had referenced if there was any new information. I don't know if that's new information, but that is where the background of how we've derived at pursuing this once again. That's number one. Number two is I want to just clarify that when I said we've never repealed it, if I said that there was never an attempt, I'm correcting myself, is that if there was an attempt, we've never successfully repealed the pilot. So that's where the statement comes from.
Okay.
So thank you very much, Madam Speaker.
You're welcome, Senator. So we're going to take a recess until 2 o'clock this afternoon. We're still on Bill 185. I have Senator Nicholas on the list, and if there's anybody else interested, then by then, please let me know. Okay, we are in recess.